Greetings and welcome to the latest installment of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus, among other things, on helping growing businesses and their owners. Today, we are taking a break from our ongoing 50 state series to review another timely topic: the top 5 considerations for business owners when selling or transferring their businesses and what they often forget. But first, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications covering accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. Now, on to business. Consideration number 1: read your operating or shareholder agreement before you do anything else. If you don't have one, speak with an attorney. The operating agreement is the governing document of the company. It controls whether an interest can be transferred or sold, to whom it can be transferred or sold, and under what conditions. Many operating agreements contain restrictions on transfers or sales, including rights of first offer and rights of first refusal that require the selling owner to offer the interest to existing owners before offering it to a third party. Some agreements prohibit transfers without the unanimous or majority consent of the other owners. Some require that the buyer be approved by existing owners. If the agreement is silent on transfers, state laws step in to fill the gap, and the default rules vary by state. In many states, the default rule is that a transferee receives only the economic rights of the interest, not the governance rights. If these terms sound like Greek to you, this is your signal to speak with an attorney before proceeding. All of this means that the buyer receives distributions but cannot vote, cannot participate in management, and cannot access the books and records of the company. Again, read your documents because the specifics will vary. If the buyer wants full membership rights, the operating agreement or the shareholder agreement must grant them. Failing to address this important component before the transaction closes creates disputes that end in litigation. Read the documents first. If it does not address transfers, amend it before sale, not after when it is too late. Number 2, decide whether you are selling the interests in the form of membership units for an LLC or shares in the case of a corporation. Or, on the other hand, are you selling the assets? These are 2 very different transactions, what we will call a stock sale or an asset sale, with very different legal, tax, and practical considerations. A membership interest sale transfers ownership of the entity itself. That is a good thing for the seller. The buyer steps into the seller's shoes. The company continues to exist without interruption. Its contracts, bank accounts, federal employer identification number, assets, and liabilities carry forward. The buyer inherits the company's history, including any tax obligations, pending claims, both known or unknown, or compliance gaps that existed as of and before the closing date. An asset sale, on the other hand, and by contrast, transfers specific assets out of the company to the buyer. This is probably more favorable for the buyer in many cases, and almost always less favorable for the seller. The company continues to exist after the sale, but it no longer holds the assets that were sold or transferred, and the seller retains the existing entity and its liabilities unless the purchase agreement allocates them otherwise. From the buyer's perspective, an asset sale is favorable because the buyer can pick and choose which assets to acquire and leave the liabilities behind. From the seller's perspective, a stock or membership interest sale is simpler and cleaner because the entity transfers as a whole. The tax treatment differs as well. In a membership interest sale, the seller recognizes gain or loss on the sale of a capital asset. In an asset sale, the gain or loss is allocated across individual assets based on their fair market values, which, if that sounds complicated, it certainly can be. And some of those assets may generate ordinary income rather than capital gain. The choice between these two structures affects the purchase price, the tax bill, the risk allocation, and the timeline. It must be decided before negotiations begin, not at the 11th hour. Number 3, understand the buyer is purchasing your problems in a stock sale or a sale of membership interests. Every company history has its history carried forward. If the entity has unfiled tax returns, outstanding tax liabilities, pending litigation, regulatory violations, or contractual defaults, those do not disappear when the membership interest changes hands. The buyer simply inherits them unless we're talking about an asset sale. And then we have to talk about liens, which is another topic for another day. A competent buyer will conduct thorough due diligence before closing, and that due diligence will uncover issues that the seller may not have known existed or may have hoped would go unnoticed. Unresolved compliance gaps reduce the purchase price or kill the deal. A seller who prepares for due diligence before listing the company for sale will negotiate from a position of strength, whereas a seller who waits for the buyer to find the problems or tries to sweep them under the rug will negotiate from a position of weakness. Before you sell, check the books, file the returns, resolve the disputes, and confirm that the entity is in good standing in every jurisdiction where it conducts business. The cost of doing this before the sale is a fraction of the reduction in purchase price that will be negotiated by a buyer discovering it during diligence. Number 4, the state where the LLC is domiciled will affect the transaction. Different states impose different rules on the transfer or sale of interests, the approval requirements for a change in ownership, and the tax treatment of the sale. Some states impose transfer taxes or fees on the change of ownership. Some states require the filing of amended articles of organization when the membership changes. Some states impose withholding obligations on the buyer when the seller is a non-resident. If the company is domiciled in a high-tax state, the seller may inadvertently owe state income tax on the gain from the sale, and the buyer may inherit an entity that is subject to ongoing obligations in that state. If the seller intends to relocate the entity to a new state before or after the sale, the seller should consider redomestication, which is the lesser known legal process that accomplishes that transfer without dissolving or liquidating the company, without creating a new entity, and without triggering federal income tax, but only when performed with the strict formalities required under the Federal Internal Revenue Code, applicable Treasury regulations, and the statutory frameworks of both the destination and departing states. Number 5, valuation. I will tell you point blank that most valuations are not worth the paper they are printed on, regardless of how many letters are after the evaluator's name. Valuation is simple. What will the buyer pay? It's not a made-up number based on a fancy spreadsheet. It's not based on future cash flows, although those can be a good starting point when the numbers are sound and the assumptions are good. All of that to say, we really should make valuation a video unto itself or save that for a future presentation. But for now, we'll just say this. The value of a company is not what the owner thinks it is worth. It is not what a comparable business sold for 6 months ago. It is not simply a multiple of revenue. A formal valuation performed by a qualified professional using accepted methodologies establishes what might be the fair market value of the business based on its specific financial performance, assets, liabilities, market position, and risk profile. Without a valuation, the seller is guessing. And by the way, don't show the valuation to the buyer. The buyer should make the offer. Otherwise, you're negotiating down and against yourself using the anchoring effect, as it is called. A seller who sets the price too high will not attract buyers. A seller who sets the price too low, and I see that all the time, will leave money on the table. Evaluation also serves a defensive purpose. If the Federal Internal Revenue Service or a state taxing authority challenges the reported gain on the sale, a contemporaneous valuation performed by a qualified professional provides a starting point for the defense. Notice I said starting point. If the company has multiple members and one member is buying another out, evaluation can protect both sides, I should say, from claims that the transaction was not conducted at arm's length. The cost of evaluation is small. I like to say it's like a home inspection. You don't really need one until you do. So just get one, but realize the value of it may be quite limited. And the cost of not having one can be significant. Now, those are 5 considerations. Check the agreements, decide between a sale of interests, be that membership interests or stock, or an asset sale. That needs to be decided early, not late. Clean up the entity before diligence begins, evaluate the state of domicile and whether redomestication should occur, and get a valuation even though its utility may be limited in many cases. If you have questions regarding potentially selling your existing limited liability company or corporation, please use the link in the description to connect with me. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is necessarily general in nature and is not legal or tax advice, because that advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.